This is the moment a First Lady walked into a legal trap of her own making. What I'm about to explain to you is something we almost never see in American legal history. The First Lady of the United States is about to be forced to answer questions under oath about her marriage, her living arrangements, her tax filings, and her connections to Jeffrey Epstein. And here is the thing that makes this genuinely unprecedented. She did this to herself. Her own legal team made a catastrophic miscalculation, and now there is no way out. This is not speculation. This is not anonymous sourcing. This is happening right now in federal court, and the implications are staggering. According to court documents filed in New York federal court, Melania Trump's attorneys made a tactical decision that has backfired spectacularly. They moved a defamation case from state court to federal court, thinking they were gaining an advantage. Instead, they triggered a legal procedure that will now force the First Lady to reveal intimate details about her life that she has spent years keeping private. We are going to walk through exactly how Melania's legal team made this catastrophic error. We are going to explain the legal trap called jurisdictional discovery that she cannot escape. We are going to reveal the devastating questions she will now have to answer under penalty of perjury. And we are going to show you why even a Trump-appointed federal judge probably cannot save her from what comes next. The First Lady threatened a billion-dollar lawsuit to silence a journalist. Instead, she gave him the legal right to depose her about everything. This is legal malpractice, and it is going to expose secrets the Trump family has fought for years to hide. To understand how we got here, we need to rewind to October 2025. According to publicly available documents, veteran journalist Michael Wolff received a letter from Alejandro Brito, a Coral Gables attorney who has become Donald Trump's go-to legal attack dog for silencing critics. The letter was a demand: apologize, retract everything you have written about Melania Trump's connections to Jeffrey Epstein, or face a billion-dollar defamation lawsuit. That is billion with a B. According to Wolff's own court filings, most people who receive these letters from the Trump legal machine do one of two things. They either comply immediately, issuing what Wolff described as North Korean-style confessions and apologies, or they go silent and pray the threat goes away. This is the Trump legal playbook: threaten massive financial destruction, force critics into silence through intimidation, avoid ever actually having to prove anything in court. But Wolff did something different. Instead of cowering, instead of apologizing, instead of going silent, Michael Wolff ran straight to New York State Supreme Court and filed a preemptive lawsuit against Melania Trump. Think about what that means. He sued her first. In his filing, according to court records, Wolff laid out every single statement Melania's lawyers claimed was defamatory. And he explained in methodical detail why each statement was either demonstrably true, fair and accurate reporting, constitutionally protected opinion, or taken completely out of context by her legal team. But Wolff did not stop there. He went on offense. He called the Trump legal strategy exactly what it is: a pattern of strategic lawsuits against public participation, known in legal circles as slap suits. These are lawsuits filed not to win, but to intimidate critics into silence, to drain their resources through endless legal battles, and to create what Wolff described as a climate of fear. This is where Melania Trump made the biggest legal mistake of her life. Her legal team, rather than fighting in New York State court where Wolff had filed, decided to do something clever. According to court filings, they filed what is called a notice of removal, attempting to move the entire case to federal court. On the surface, this might seem like reasonable legal strategy. Federal court has different procedures, different rules of evidence. Defendants often prefer federal judges to state court juries. And in what can only be described as Trump luck, the random selection process assigned this case to Judge Mary Kay Weisskell, a Trump-appointed federal judge in Manhattan. This is the same judge, according to public records, who ruled against Manhattan prosecutor Alvin Bragg when he tried to quash a congressional subpoena. The same judge who denied Columbia University's attempt to challenge Trump administration funding cuts. So Melania got her Trump judge. She got her federal court. Everything should be going according to plan. But here is what they missed. To remove a case from state court to federal court, you need a legal basis for federal jurisdiction. The most common basis is called diversity jurisdiction. What this means, according to federal procedure rules, is that the two parties in the lawsuit must be citizens of different states. If both parties are from the same state, there is no diversity and the case stays in state court. Period. Michael Wolff is from New York. That is not in dispute. So, for Melania Trump to move this case to federal court, she has to establish that she is not a resident of New York. She has to prove that she is a citizen of a different state, presumably Florida, where the Trump family claims official residence. And this is where the trap closes, because now, under established federal procedure, Michael Wolff's attorneys have the absolute right to conduct what is called limited jurisdictional discovery. Let me say that again so it lands properly. Melania Trump's own legal strategy has now given opposing counsel the right to depose her, to send her written interrogatories, to subpoena her financial records, to demand her tax returns, to ask her about every single aspect of her life that relates to one fundamental question: where does Melania Trump actually live? According to legal experts who have analyzed this case, here are the questions Melania will now have to answer under oath. How many nights per year does she spend at Mar-a-Lago versus Trump Tower on Fifth Avenue versus the White House? This is not abstract. Residency determinations, according to federal court precedent, are based on where you actually physically reside, not where you claim to reside for convenience. Multiple reports over the years have indicated that Donald and Melania do not share a bedroom. Reports have consistently suggested that Melania spent very little time at the White House during Trump's first term. She was seen far more frequently in New York City, maintaining her lifestyle on Fifth Avenue, shopping, attending appointments, having lunch with friends. During the second term, her absence has been even more pronounced. She is essentially invisible at official White House functions except for occasional state dinners. Now she has to answer questions about all of it under penalty of perjury. Has she claimed Florida residency for tax purposes while actually living in New York? What about property tax exemptions? The homestead exemption in Florida is substantial, but according to Florida law, you have to actually reside there to claim it legally. If Melania claimed the Florida homestead exemption while actually living in New York most of the year, that could constitute tax fraud. Barron Trump is currently a student at New York University, located in Manhattan. According to NYU's published tuition policies, the university charges different rates depending on whether you are an in-state or out-of-state student. The difference is substantial. What did the Trump family claim on Barron's application materials? Did they claim New York residency to get in-state tuition benefits? If they did, that would directly contradict Melania's claim to be a Florida resident for jurisdictional purposes. The underlying defamation claims involve statements about Melania's connections to Jeffrey Epstein's social circle. According to court filings, the statements Wolff made include that Melania was involved in the Epstein situation, that she could be the missing link in Trump's ties to Epstein, that she was involved in Epstein's social circle, and that is how she met Trump, and that she was introduced to Trump by a model agent with whom both Trump and Epstein were involved. Wolff's defense, according to his court filings, is that these statements are either demonstrably true or fair and accurate reporting based on documented facts. Melania was a model with Elite Model Management, an agency run by people who were friends with both Trump and Epstein. She met Trump at a party hosted by the modeling agency. These are documented, verifiable facts in the public record. Now she will have to answer questions about all of it under oath. Some might think that Judge Wiskel could simply limit the scope of discovery to protect Melania. After all, she is a Trump-appointed judge with a clear track record. But here is the fundamental problem with that theory. According to federal civil procedure rules, jurisdictional questions are not matters where a judge can simply side with whoever they prefer. The rules are explicit. If there is a legitimate dispute about diversity jurisdiction, the party seeking federal court has to prove their case, and the opposing party has the absolute right to challenge that proof through discovery. Even a judge who desperately wants to help Melania Trump has to follow the law. And the law says that if Wolff's attorneys can articulate a good faith basis for questioning her residency claims, they are entitled to discovery on that issue. Given everything that has been publicly reported about Melania's living arrangements, there is clearly a good faith basis for that challenge. Legal analyst Lisa Rubin, who covers federal court proceedings, has stated in media appearances that jurisdictional discovery is one of the few areas where trial judges have very limited discretion. If the opposing party makes a colorable challenge to jurisdiction, discovery must be permitted. This is the beauty of Wolff's legal strategy. By filing the preemptive lawsuit in state court, he forced Melania's team to make a choice: fight in state court or remove to federal court. If they stayed in state court, they faced a jury that might be sympathetic to a journalist defending his First Amendment rights. If they removed to federal court, they triggered jurisdictional discovery. Either way, Melania loses. And here is the truly devastating part. Melania is enduring all of this legal exposure to pursue a defamation case she is likely to lose anyway. According to court documents, the specific statements Melania's lawyers claim are defamatory are remarkably weak. Wolff's defense, according to his filings, is that statements were taken completely out of context, represent fair and accurate reporting based on documented facts, or are demonstrably true. To win a defamation case, Melania would have to prove that these statements are false, made with actual malice or reckless disregard for the truth, and caused her actual damages. But if the statements are true, or substantially true, or constitutionally protected opinion, the defamation case fails. Period. Legal experts who have reviewed the filings say that Wolff has a very strong defense. The statements are either verifiably true based on public records, or they are protected as fair commentary on matters of public concern. So what we have is a situation where Melania Trump is facing invasive jurisdictional discovery that will expose her private life, enduring questions under oath about her marriage, her finances, her tax returns, subjecting herself to potential perjury charges if she lies, all to pursue a defamation case she is likely to lose. This is legal malpractice territory. For Donald Trump, this has to be an absolute nightmare scenario. Trump has spent his entire career controlling information, managing his image, using legal threats to suppress unfavorable coverage. And now his own wife's legal strategy is about to put their marriage, their living arrangements, their financial dealings, and their Epstein connections into the public spotlight under oath. According to federal procedure, depositions are typically recorded. Transcripts become part of the public court record. When Melania sits down to answer questions, every word she says will be documented, preserved, and available for journalists, investigators, and the American public to examine. If Melania lies under oath about where she lives, about her tax filings, about her relationship with her husband, she could face perjury charges. If she tells the truth, she exposes the Trump family's financial arrangements, their separate living situations, and potentially their tax avoidance strategies. Either way, Donald Trump loses. This is all happening 9 months before the midterm elections. Every revelation from Melania's deposition will become a news cycle. Every contradiction between what she says and what the Trumps have publicly claimed will be analyzed and weaponized. The political damage could be catastrophic. This is where we stand on January 30th, 2026. The First Lady of the United States is trapped in a legal nightmare of her own making. She threatened a billion-dollar lawsuit to silence a journalist who wrote about her Epstein connections. Instead, she gave him the legal right to depose her about every aspect of her life. She moved the case to federal court, seeking a favorable judge. Instead, she triggered jurisdictional discovery that will force her to answer questions under oath about where she actually lives, whether she shares a bedroom with her husband, what her tax returns say, and whether she committed tax fraud. Her legal team made a catastrophic unforced error. And now there is no escape. This is what happens when the legal system works as designed. This is what accountability looks like when someone finally refuses to be intimidated by wealth and power. The discovery process is beginning. The depositions are coming. And when Melania Trump sits down to answer questions under oath, every word will be documented, preserved, and scrutinized. She sued to silence the truth. Instead, she guaranteed the truth will come out.